Well, well, well. This is daily news from Inquirer and Philly.com. And retired Supreme Court Justice John Paul Stevens' Second Amendment is a relic of the 18th century. If we look here, it's I'll zoom in just a second. March 27th, 2018. This is the old fort. He's 95 years old. He's a relic of the long time ago. He's a relic. But anyway, this former justice, he was a nitwit even back in the day. He has a strong message for the teenagers who led the march over the weekend for tighter gun control. Demand to repeal the Second Amendment. An opinion published in the New York Times on Tuesday, the 97-year-old retired justice who was nominated by the court by Gerald Ford, they're often ruled more liberal. The only way to create a path for significant gun control legislation was through a full repeal of the Second Amendment, which protects the rights of Americans to keep and bear arms. Concerned that a national standing army might pose a threat to the security of separate states led to the adoption of the amendment, Stevens wrote. Today that concern is a relic of the 18th century. Stevens wrote, the NRA is a propaganda weapon with immense power. The decisions even going back to 1939 when the court ruled against the United States versus Miller that Congress could ban ownership of short-barreled rifles had no connection to the military or military activity. Neither the text of the amendment nor the arguments advanced by its proponents evidence the slightest interest in limiting end legislation. Specifically, there is no indication that the framers of the amendment intended to enshrine the common law right of self-defense in the Constitution. Okay, now I'll get back up here. I already showed you that the guy's a nitwit. Just using for publicity. Number one, I told you before about how they did away with Sir William Blackstone's, studying the Constitution. That people did not study the Constitution anymore, just like this fella here. He didn't study the Constitution. He was a lawyer, and he worked, in a big firm. He did not study the Constitution. He only studied what other judges wrote about the Constitution, which made the judges the law, not the Constitution. Had he studied the Constitution, he would have found out that in order to the framers of the Constitution were born and brought up in an atmosphere of the common law, and they thought and they spoke of it in its vocabulary. When they put the conclusions into the form of fundamental law in a compact draft, they expressed themselves in the terms of the common law, confident that they could be shortly and easily understood. And why this guy didn't understand it is because he never studied constitutional law, nor did he care to. He was a lawyer. The language of the Constitution cannot be interpreted except by reference to the common law in the British institutions as they were when the instrument was framed and adopted. On every question of the Constitution, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning can be squeezed out of the text or invented against it, conform to the probable one which was passed. Justice Scalia said the same thing. It says what it says, and it doesn't say what it doesn't say. This guy here is a nitwit. He never should have been placed on the bench by any person. That's what's wrong with this country. It's really what's wrong with this country. They go by what other judges said about the Constitution. They haven't read it. And A judge can be just as flawed as anybody else. I don't care how many times they've written law, doesn't mean that they understand it. Well, enough of that.